Welcome back. Let's just recap a bit the two important chapters, 3 and 4, by Dr. Griswold del Castillo, who is an authority on the Treaty of Guadalupe Hidalgo, formerly at San Diego State University, where Professor Gomez and I also worked for many years. In chapter 3, Griswold will introduce us into the debate about ratification in both the United States and Mexico. In Mexico, a very heated debate between Manuel Crescencio Rejón and Bernardo Couto over whether or not to sign the Treaty of Guadalupe Hidalgo took place. Rejón, as you know by now with your readings, proposing that the treaty not be signed and to continue the war. He felt the treaty was a sentence of death, he said. While Bernardo Couto proposes that there's not much more that can be done. Mexico is defeated and must find the easiest way out of this problem, of course, of war with the United States. On the American side, we look at ratification taking place between those who propose taking more Mexican territory, maybe all of Mexico, and those who will be happy, if you will, with the sufficient obtaining of the northern territories. In chapter 4, we deal with a very important question: citizenship and property rights. And we're introduced into some very important hallmark cases involving the Treaty of Guadalupe Hidalgo. The first case is People versus de la Guerra in 1869. A very, very important case that finally settles the question about how and when a Mexican national could become a United States citizen. You might recall that in Article 8 of the Treaty of Guadalupe Hidalgo, a choice was given to the former Mexican nationals to either retain the status of Mexican citizens or to become U.S. citizens. The problem, of course, is that the article never tells you how or when the process will be executed. For many Mexican origin people back then, they believed that just making the choice would suffice. However, it took this important California Supreme Court case to settle that question of when, again, a Mexican national could become a United States citizen. Ironically enough, you have Pablo de la Guerra, who wants to run for a district position, district judge. His opponents say, no, you can't. You're not an American citizen. The courts, of course, get involved, as well as the Congress. And they decide that a Mexican individual who chose to become an American citizen, if you will, that right happened when a territory became a state of the Union. Which, again, in the case of California, it was in 1850. But this case took place in 1869. Consider that irony. Let's move on now and discuss an important case that involves property. Again, People versus de la Guerra involved civic rights. Now we're dealing with land and property issues. In the Treaty of Guadalupe Hidalgo, we see that land will be protected. Even absentee land ownership had rights to their property. But in 1851, in the state of California, you're going to have a law passed that is entitled the Law of 1851, Land Law Act of 1851, which requires all Mexicans, only Mexican people, to prove the land is there within 2 years. For whatever reason, the family of Dominguez, the owners of these properties, did not feel that they had to go prove the land was theirs. From their perspective, for example, in the Treaty of Guadalupe Hidalgo, no such thing was required. So even though they possess legal and ample documentation that proved their ownership was legitimately theirs, they did not go on to prove the land was theirs within those 2 years allocated by the state of California. The local courts ruled in their favor, saying, yes, you do not have to prove that. There's nowhere in the treaty that says you have to prove the land is yours. But the court eventually goes on, go on to the Supreme Court of the United States, where the court says now that at any time, the federal government or any institution, frankly, of government can require proof of ownership. But what's most damaging about that particular case is the fact that the Supreme Court of the United States says that it has no power over such a treaty. In doing so, of course, it minimizes the validity or the importance of the Treaty of Guadalupe Hidalgo, which many Mexican origin people counted to protect their civic and their property rights. The result of this, of course, is that Mexican people began to lose their land, their property, and eventually, of course, the status in the American Southwest. In Botiller versus Dominguez, the Supreme Court held that the sovereign laws of the United States took precedence over international treaties. This appeared to contradict the Constitution of the United States in Article 6, Section 2, and Article 3, Section 2, Clause 1, which gives the treaties the same status as the Constitution. In other words, if you remember briefly, when Bernardo Couto, who was for the treaty to be signed to protect the Mexican people, he said Articles 8 and 9 would be sufficient. In this argument, again, by the United States Supreme Court in Botiller versus Dominguez, that seems to be a nullified argument.